the first to know in Nsem-Pii TV.
Mr. Nsem-Pii, our MP elect for Akwatia constituency, are in a case against Koforidua High Court judge. Our ruling say they are convicting of a contempt and he should be arrested and sentenced to prison. Now, and then Supreme Court's Akwatia led by 5 judges and a cases. Minority Eka say case here NDC for the call of High Court say Akwatia MP enye duly elected. And until swearing in a year or more on the 6th of January at the Bechi Amaya swearing in of the president, our parliament. Montungu. Nano Emma courts, high courts of Ubia Equatana Semno so Justice Senor Amedehe Eka say Eyadia say Akwatia MPM file any case or to hear the case and into court. That's what one is a friend into a convicting or contempt. Eka say yenko arrest no. Na yemfa high court na court and sentencing no into prison. And no minority no emuni ya kumamudo kopie mu was Supreme Court. Eka say the MP is seeking the court to prohibit the trial judge from going ahead to sentence him pending the hearing and determination of the case before the apex court. Now the woman say minority ni stand and say a minority no they are seminal kopie mu Supreme Court. Ewo NDC for action automatically ewo high courts on the case. And so high court no it means substantially all those cases and ewo Supreme Court no. It means rule case no in favor of NDC. A ruling contempt. Say yenche no na ye in prison no. And then again, almost argue is a high court judge breached the rules of natural justice when he proceeded to hear and determine the contempt application despite the pendency of the MP's motion to set aside the said contempt application for want of jurisdiction. In fact, natural justice age more nipa say what's him could more court to say yama hearing no matter what the situation. And also Omo kopie mu was Supreme Court to say there high court na busa amra no so eno nti high court and quash those rulings na high court judge no eye ni nyina na the Supreme Court by a 4:1 ratio ruling by the Supreme Court judges no there almost throughout the judges ruling on Mr. Nsem-Pii as a busan for yedi emunsem edi ebremo
Warrant for the arrest of Ernest Yakumi, the presumed winner of the Akwatia Parliamentary seat or elections in the 2024, in the 2024 election. Now, after convicting him of contempt of court, but minority describes court ruling as unfair and unsatisfactory. Plus, President Nana Akufo-Addo has been telling his former appointees, quote, no running away from accountability, unquote. I mean, we know the recent happening between the OSP and the former finance minister, and the information out there that several of his appointees have left their jurisdiction. This is where the former president is saying, do not run away from accountability, come and answer to all the questions. And so these issues plus more to digest this morning with our panel, and we'll be joined in studio, by Dr. Kabiru Mahama. He is the MP for Wale Wale. He used to be an aide in the the former vice president's office. Kabiru, good morning. Trials all is well?
All is well. It's been a while.
Yeah. I'm around.
I have a question on the lighter note. So just a few days in office and you already have grey hair, or were they there all along?
I'm sure the pace of graying is
to Parliament. He was sworn in. He's participated in parliamentary proceedings for a month or so now, and now they're calling for his arrest. Minority Leader Alexander Penyumakin is saying that the way we are treating this man is unfair, and that he in fact wrote to the judge saying that he's been busy with parliamentary duties, which is why he failed to show up in courts when the case was being heard. Doc, I'll come to you in a second. Let me start from Mr. Wanda Madilo. What did you make of it? Have you been following how this whole case is unraveling?
First and foremost, before I answer that, I want to talk to Kabiru, Honorable. I think that your conflict, first and foremost, it explains why you have the grade. Now that we know the problems go beyond the internal party wranglings before your assumption of office. But we need to be calm about this matter. You see, conflict knows no political party colors. And what is happening in Waliwale is something that nobody wished for or wants. I mean, what's the business of government imposing curfew? When, at the end of the day, that curfew affects governments the more because productivity then is zero at night in those areas. And we all know that Waliwale is a very huge farming or agricultural-based community. And some of the things they do, like adding value to their produce, is done overnight. So, indeed, no government would want to happily, impose curfew in Waliwale if it is not for security concerns. You will recall that the regional minister actually went there. So that itself is what he's being called for as being in contempt. You see why, in this case, the judge wouldn't have taken into account the clerk or the who did the swearing at the time? It was a clerk, right?
Yes, the clerk.
Why they didn't pull the clerk into this case? Because the clerk was aware and gave clear instructions. We have received, we have been served. Are you still going to go ahead? He said yes, was going. So by that action, the clerk has actually recused herself from the consequence of being in contempt. Okay. So the very representation you are talking about is what was challenged in the first place. So to the court, you are not a representative of the house, of that constituency. That's for me basically, what it is.
Okay, let's listen to Dr. Kabiru now. What is the minority's position on this matter, really? He's a member of your...
That's his colleague anyway.
Yes, he's he's a member of the minority.
So the minority is disturbed. The minority is concerned. The minority is perturbed by the turn of events. The minority is not happy with how this matter has been handled. And if you can just rewind back, Mr. Nsem-Pii, the duly elected member of parliament for Akwatia, came to the House of Parliament midnight, 6th January, to be sworn in. The clerk to Parliament drew the attention of the House to the fact that an injunction has been placed on that candidate or his election. The outcome has been challenged, and that he had been duly served. The minority took the view that Parliament procedures are exclusively within the jurisdiction of Parliament, and that there have been precedents that a member has been served with injunction, yet the member has been sworn in Parliament.
Yes.
In the case of Asinov, Member of Parliament elect then, Mr. James Jackie Kwesen. Yes. This was the argument the minority leader advanced on the floor of Parliament and stated clearly that on the basis of that precedent, it was only fair and good, and being fair to the people of Akwatia that Mr. Nsem-Pii should be sworn in by the clerk. That was our argument advanced. He again stated that the minority then, now the majority, advanced the argument that Mr. Kwesen, Jackie Kwesen, is aware of the legal implication of the act he was going to do or he was engaged in. So is Mr. Nsem-Pii. And that they were all acutely aware of the implication of that decision to get themselves sworn in despite notice of injunctions against them. That That was the argument of the minority leader.
Was an injunction brought against Jackie Kwesi?
There was an injunction against Jackie Kwesi. As a matter of fact, in the preceding of that night, 2021 January, it was made clear, and the argument was that let Jackie Kwesi bear his own cross. Similar argument was advanced by Mr. Afenyo Osahi of Afenyo Markins. What is the difference? It's clearly based on precedence. Now, the judge disagreed that Mr. Nsem-Pii has been validly elected. No, not that he disagrees. He takes an application against him, an injunction against him. He says that by the fact that Mr. Nsem-Pii has defied and proceeding ahead to be sworn in as a member of Parliament for Akwatia, he has acted in contempt of court.
Is he wrong?
He's wrong, because the judge is not the law in himself. There are superior authorities over him. A high court judge is subservient to the laws of the country, just like the court exists and is answerable to another court. In other words, there are other courts with jurisdiction over that court.
Great.
Okay, so it is not that the gentleman acted in complete disregard for the ruling. There were processes filed at the High Court, the Supreme Court, which in his interpretation operates as a stay of whatever is going on in the High Court.
So what you're telling us today is that there was a process started at the Supreme Court.
Clearly.
No. Is it a fact?
That's what I'm saying. I have even the minority, together with the lawyers for Mr. Kumi, has appealed even this decision as a file for scale of execution. And we have advanced our files. And once court documents are filed, they become public records and they can be cited. I have the complete dossier here. And I can share them with you. I can read copiously of the processes. Okay.
So there are two things you're saying here, Kabiru.
Yeah.
One, you're saying that you filed processes against that ruling, right? The issuance of the bench warrant.
Exactly.
My question to you earlier was on your earlier statement that the party, he had filed processes at the Supreme Court, staying the process at the court today. That's what I was asking, whether it's a fact that had been done prior to this judgment.
One of our grounds for the appeal